Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Let us start with a crucial development where the Supreme Court today held that state of West Bengal's suit against the union government over registration of cases by the CBI despite revocation of its general consent is maintainable. It was in November 2018 when the state government withdrew its consent that allowed the CBI to conduct investigations of cases in the state of West Bengal. The suit was filed against the union under Article 131 of the Constitution, which deals with the Supreme Court's original jurisdiction in a dispute between the centre and one or more states. In its suit, the state contended that despite revocation of its consent for the central agency under the Delhi Special Police Establishment Act or DSPE Act, the CBI continued to register FIRs in respect of the offences that took place within the state. During the hearing, the union had raised preliminary objections regarding the suit's maintainability. It was argued that Article 131 was designed to settle disputes between federal units of government and did not extend to the CBI, which was not a limb of the central government. The state of West Bengal argued that Article 131 provides for an independent adjudication in case of federal disputes and should be widely interpreted to advance the remedy. It was argued that supervision of the police establishment is with the Department of Personnel and Training as per the administrative structure of the union, and that when a question on CBI is asked in the Parliament, it is answered by the Department of Personnel and Training. The court, after the hearing, had reserved its verdict in May this year. Rejecting the preliminary objections raised by the union, the bench comprising Justices B.R. Gawai and Sandeep Mehta has now held that the plaint of the state of West Bengal disclosed a cause of action. The bench also rejected the argument taken by the union that the state had suppressed material facts in the plaint. It held that for the purpose of determining whether the suit is maintainable and it disclosed any cause of action, the averments in the plaint have to be taken at the face value. The matter is next posted on 13th August now for framing of the issues. Chief Minister Arvind Kejriwal has informed the Delhi High Court that he is a victim of a witch hunt by the Enforcement Directorate and that revoking his bail in the money laundering case would be a miscarriage of justice. Opposing ED's plea against granting bail, the Chief Minister in his reply has stated that ED uses illegal tactics to pressure other co-accused into making incriminating statements by promising not to object to their bail. Kejriwal was granted bail by the vacation judge Mr. Nyay Bindu of Rouse Avenue Courts on June 20th. On ED's challenge, the Delhi High Court stayed the impugned order on 25th June. Refuting ED's allegation that the trial court did not give it fair opportunity to address the arguments, Kejriwal has said that the bail order was not only well-reasoned, but prima facie showed due application of mind in considering as well as faithfully recording relevant arguments and contentions raised on behalf of both the parties. It adds that no offence is made out against Kejriwal under Section 3 of PMLA, and therefore his life and liberty must be protected from unwarranted and unjustified violation at the hands of ED on the basis of a false, malicious and motivated case without any merit. Kejriwal has further said that since nothing relevant was probed by the investigating officer during his ED custody, the arrest was illegally made just to harass and humiliate a political opponent. The matter was listed today for hearing. However, Justice Neena Bansal Krishna adjourned the hearing to 15th July as ED requested time to file its counter affidavit to Kejriwal's reply. The Supreme Court bench comprising CJI D.Y. Chandrachud and Justices J.B. Pardewala and Manoj Mishra has today reserved judgment on a plea by an NGO seeking due implementation of Prohibition of Child Marriage Act. The court today remarked that programs and lectures aimed at creating awareness do not really bring about a change on the ground level. During today's hearing, Additional Solicitor General Aishwarya Bhati appraised the court that the status report called for earlier had been placed on record now. The same provided state-wise data of 29 states and union territories on the number of child marriages reported, number of cases of child marriages prevented, number of cases in which FIR was registered, etc. for the past 3 years. She asserted that there was a significant improvement in the child marriage statistics compared to the years 2006 and 7. The SG also informed the court that most states give additional charge to district magistrates, etc., to deal with the issue of child marriage. One state, however, that is the state of Andhra Pradesh, has outrightly said that it gives no such additional charge. The submissions of the ASG, however, were countered by the counsel for the petitioners in this matter, who argued that child marriage protection officers were contemplated by the Act for a purpose looking at the scale of the problem. If additional charge is given to the district magistrates, etc., they would neither have the human and monetary resources nor the time to monitor the issues. The counsel for petitioners also argued that no data was available regarding how many prosecutions led to any kind of conviction. The counsel for the petitioners further claimed that there were certain states which were severely plagued by the issue and that there was no congruence between the numbers available. Though some suggestions were put forth by the petitioners today, the court, while reserving the judgment, called on the counsels for the petitioner, NGO, and union to place before it some concrete suggestions that could be put forth to governments as guidance. The Supreme Court today held that a Muslim woman is entitled to file a petition for maintenance against her husband under Section 125 of CRPC. The bench of Justices B.V. Nagratna and Augustine George Massey dismissed a petition filed by a Muslim man against the direction to pay interim maintenance to his divorced wife under Section 125 of CRPC. The court held that the Muslim Women Protection of Rights on Divorce Act will not prevail over the secular law. The two judges have delivered separate but concurring judgments. The bench clarified that if during the pendency of a petition under Section 125 CRPC, a Muslim woman is divorced, then she can take recourse to the Muslim Women Protection of Rights on Marriage Act of 2019. The bench stated that the remedy under the 2019 Act is in addition to the remedy under Section 125 CRPC. This case arose from a family court order wherein a Section 125 CRPC petition preferred by a Muslim woman, the court directed the petitioner, that is her husband, to pay interim maintenance of 20,000 per month. This order was challenged before the High Court of Telangana on the basis that the parties got divorced as per personal laws in 2017. The High Court did not set aside the direction for interim maintenance and only reduced the quantum to be paid. Therefore, the husband approached the Supreme Court pleading that a divorced Muslim woman is not entitled to maintain a petition under Section 125 of CRPC and has to proceed under provisions of Muslim Women Protection of Rights on Divorce Act, which restricts Muslim women right to maintenance to 90 days after divorce, that is the iddat period. The Supreme Court today issued notice on the petition filed by Karnataka Special Investigation Team challenging the High Court's order granting anticipatory bail to Janata Dal United leader Bhavani Revanna. She is the mother of former MP Prajwal Revanna and has been charged with kidnapping a woman. She was granted anticipatory bail in the matter last month. Senior advocate Kapil Sibal, representing the Karnataka SIT, criticized the relief granted to Bhavani Revanna. Sibal pointed to the victim's statement under Section 164 of CRPC, implicating Bhavani in the victim's captivity. The bench highlighted Bhavani's age and questioned her role in her son's alleged crimes. It noted that there was no direct evidence against her and doubted her involvement in her son's alleged sexual crimes. Sibal then said that the bench should not dismiss her involvement just because she is a woman. The bench clarified that it was only considering her protection from arrest, with her guilt to be determined at trial. The bench agreed to issue notice but cautioned against politicizing the matter. In another update, the Supreme Court today issued notice to the Delhi police following allegations of harassment raised by the petitioner who filed a contempt case against the Delhi Development Authority over illegal tree felling in Delhi Ridge Forest area. You should know that the Supreme Court has taken suo motu criminal contempt action against the Vice Chairman of the Delhi Development Authority for illegally cutting the trees of Delhi's Ridge Forest for a road widening project. The court has also asked the DDA to explain the role of the Delhi Lieutenant Governor after certain emails allegedly sent by the DDA engineer to the contractor indicated that the trees were cut on the directions of the Delhi LG. The petitioner Bindu Kapuria has now complained about the police's actions, claiming that they have been subjected to undue scrutiny and harassment. Senior advocate Gopal Sankara Narayan for the petitioner informed the court that the Delhi police had been making inquiries regarding the other petitioner, that is New Delhi Nature Society, as well. He argued that the police had reached out to the bank and demanded detailed information about their accounts. He further emphasized the need for accountability, saying that the Commissioner of Police and the Axis Bank must give answers. The bench led by Justice Abhay S. Oak inquired if the police also made inquiries about other petitioner involved in the case, to which the counsel replied in positive. In response to these allegations, the Supreme Court has now issued a notice to the Delhi police seeking an explanation regarding the petitioner's claims of harassment. The Supreme Court has disposed of a batch of writ petitions filed by transporters and tour operators challenging the action of various state governments in levying authorization fee or border tax in violation of All India Tourist Vehicles Permit Rules of 2023. The petitions were filed initially when the state of Tamil Nadu started levying border tax on buses having All India Tourist Permit. Later, certain other states also followed. The states contended that they are competent to levy and collect such charges as entries 56 and 57 of List 2 of Schedule 7 of the Constitution. The top court has refused to consider the matter on merits and disposed of the petitions, giving liberty to the petitioners to raise their grievances before respective jurisdictional high courts. The bench, comprising Justices Vikram Nath and Satish Chandra Sharma, observed that so long as respective state rules are not under challenge, the actions of the states cannot be said to be bad in law. It further said that the High Court ought to be approached in the first instance. Let me tell you, recently another bench of the Supreme Court passed an interim order directing the state of Tamil Nadu to not hinder the passage of tourist buses having All India permit. Mentioning Uddhav Sena's challenge to Maharashtra Assembly Speaker's refusal to disqualify members belonging to the Eknath Shinde-led group, Senior Advocate Dr. Abhishek Manu Singhvi today urged the Supreme Court to advance the hearing of the case as Maharashtra Assembly elections are round the corner. The matter was mentioned before a bench led by CJI D.Y. Chandrachud with a request that its hearing be advanced from 19th July to 12th July. Hearing the same, the CJI told the counsels for the petitioner to circulate an email request. To give you a recap, an SLP was filed by Sunil Prabhu, MLA belonging to Shiv Sena Uddhav Balasaheb Thackeray faction, questioning the decision of the Speaker Narvekar on disqualification issue. In January this year, the Speaker had held that Eknath Shinde's faction was the real Shiv Sena, following the emergence of a rival faction within the party in June 2022. The Speaker had also refused to disqualify any member belonging to either faction. The top court issued notice on Prabhu's latest petition in January this year. In February, while deferring the hearing, the bench indicated that the question of maintainability of the petition would be considered first. In March, the Supreme Court expressed reservations about the Speaker using the test of legislative majority to ascertain which faction was the real party. It pondered whether the approach of the Speaker contradicted the Constitution Bench judgment in Subhash Desai delivered in the year 2023. The Supreme Court today adjourned a public interest litigation filed by former Rajya Sabha MP Dr. Subramanian Swamy to delete the words socialist and secular from the preamble to the Constitution of India. The petition challenges validity of insertion of these two words in the preamble of Indian Constitution via the 42nd Constitutional Amendment of 1976 during the time of Prime Minister Indira Gandhi. It is argued that such insertion was beyond the amending power of the Parliament under Article 368. The petitioners claim that the framers of the Constitution never intended to introduce socialist or secular concepts in democratic governance. It is further averred that Dr. B.R. Ambedkar had rejected the incorporation of these words, as the Constitution cannot thrust upon the citizens certain political ideologies by taking away their right to choose. Today, the matter was placed before the bench led by Justice Sanjeev Khanna. Considering that there are 3 petitions on the same issue and the petitioner counsel in one of the pleas sought for accommodation, the court ordered the matter to be relisted in the week commencing from 12th August. While doing so, Justice Sanjeev Khanna also said that so far as the word secular was concerned, there are a number of judgments of the Supreme Court holding that it is a basic structure of the Constitution. Also, let me tell you that Rajya Sabha MP Binoy Viswam of the Communist Party of India has filed an intervention in this matter, opposing the petition by saying that secularism and socialism are inherent features of the Indian Constitution, and hence the addition of these words in the preamble did not alter the nature of the Constitution. The Calcutta High Court has admitted the defamation suit filed by Bengal Governor C.V. Anand Bose against Chief Minister Mamata Banerjee for making allegedly defamatory remarks against the governor in light of recent sexual harassment allegations against him. A single bench of Justice Krishna Rao admitted the suit for hearing while observing that no defamatory remarks shall be made in the interim period till the suit is heard. The plea comes in the aftermath of Chief Minister allegedly making comments against the governor, stating that she had been informed by women that they did not feel safe visiting the Raj Bhavan due to the recent allegations of sexual harassment against the governor by a former Raj Bhavan employee. The Karnataka High Court has today initiated a suo motu case taking note of the rising number of dengue cases in Bengaluru and other districts of the state, especially rural areas. A division bench of Chief Justice N.V. Anjaria and Justice K.V. Arvind said that right to health and right to be treated and right to live in a healthy environment is a fundamental right flowing from Article 21 of the Constitution. The court took note of the letter written by a citizen which was published in the Deccan Herald newspaper and other related news articles pointing to the several cases of dengue. The court issued notice to the state government, chief secretary, health secretary and directed them to respond regarding preventive and remedial measures taken to check the spread of dengue in Bengaluru and other districts of the state and to provide medical facilities in the city of Bengaluru and in rural areas, etc. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.